Good morning. Gabrielle closed the door, so I think that's my cue to welcome you all. I am Jessica Hott. I'm one of the Associate Deans here at the College of Law, and on behalf of the Dean and my colleagues, I'm pleased to welcome you to Day 2 of the West Virginia Law Review Symposium. As you can see, Morgantown in February does not disappoint, so we are particularly grateful for everyone who has traveled with us to be with us both yesterday and today. As many of you know, the West Virginia Law Review is the 4th oldest law review in the country. Its mission is to advance legal dialogue through a student-governed process that cultivates leaders, fosters collaboration, and provides a platform for diverse scholarship. This year's topic on home rule certainly fulfills that mission. This timely and important topic is rich with a variety of diverse and exciting topics for scholarship, from LGBTQ protections to gun regulation to the impact of the West Virginia Home Rule Pilot Program, criminal justice reform, consumer law, issues in environmental and energy law, and the role of courts. I'm sure you would agree that that is a diverse area of scholarship. I would like to thank all of the panelists, including the scholars, experts, and attorneys that have volunteered their time and traveled to enrich this discussion. I also want to thank the panelists and speakers for their time, including my colleagues who have either volunteered to serve as moderators or to also serve as panelists. I'm very fortunate to work with such amazing law professors and scholars who dedicate their time to supporting the work of the Law Review in the College of Law. And I would be particularly remiss if I did not take a moment to thank all of the members of the West Virginia Law Review who have worked tirelessly to make this symposium a success. We have amazing students here. I hope you've had a chance to speak with our students. So I'm just going to have our Law Review members sort of raise their hands. And I would like all of us to give them a round of applause for their very hard work. Specifically, I do want to recognize that this symposium would not have come together without the individual efforts of our symposium editors, Gabrielle Markham and Austin Rogers. Could you please raise your hand? Thanks to Gabrielle and Austin. They have done a great job. I don't see Professor Richardson in here, but for those of you who know, Professor Jesse Richardson was our faculty symposium advisor, and his expertise also made this symposium a great success. So we are incredibly grateful for Professor Richardson's time to advance the scholarship here today. Professor Joshua Weishart, I don't think he's in attendance, but I do want to thank him as well. He is our faculty advisor and director of our Writing Center. Melanie Steinling have worked also this year with our West Virginia Law Review. We have a number of faculty and staff who work behind the scenes to make this event a success, and so I would like to thank all of them. We are, again, just grateful that you have made the time and effort to travel here to be with us today. So I look forward to another day of great discussion and dialogue on this important topic of home rule, and we are just pleased to have you. So enjoy Day 2. Thank you very much.
Good morning, everyone. My name is Hope DeLap, and I'm the Justice Franklin D. Cleckley Fellow for the West Virginia Innocence Project. The Innocence Project is part of the clinical law program here at the College of Law. Today, I am joined by two wonderful panelists from Marshall University. Professor Casey Baker, all the way at the end there, serves as Assistant Professor of Legal Environment in the Division of Accountancy and Legal Environment at the Lewis College of Business at Marshall University. He teaches topics such as legal environment of business law, of business and business law, government regulation, healthcare law, and entrepreneurial law. His research covers a variety of commercial and corporate law topics, including debt collection and bankruptcy, corporate governance, securities, and energy and natural resources. In addition, Professor Baker maintains a practice of law in West Virginia and Ohio, focusing on governance and transactional matters for small businesses and not-for-profit organizations. Professor Ralph McKinney, Jr., to my right, is an assistant professor of management at the Lewis College of Business at Marshall University as well. Professor McKinney has authored a number of publications concerning cryptocurrency, economics, forensic business practices, human resource management, indigent criminal defense, and poverty. He holds degrees from Aston Business School at Aston University in Birmingham, England, Marshall University, and West Virginia State University. Additionally, he is a licensed private investigator. Today's panel focuses on home rule and criminal justice reform. Home rule allows municipalities to respond to individual demands through tailored regulation, but greater local control can cause tension between the state and local governments. Our discussion today will center on one issue in particular, the indigent defense system in West Virginia. I'll start by asking Professors Baker and McKinney some questions about the indigent defense system and how it works on a state and local level before opening it up for questions at the end. To start, with both of you having diverse research interests and different backgrounds, what brought the two of you together to co-author an article on indigent defense in West Virginia?
So, our background, as you heard, is in business. So why do we have two business professors up here talking about criminal law? Well, because we come at this from a policy perspective. We come at this from an administrative perspective, trying to sort out what is the mission, what is the purpose of an indigent defense system. Being both of us native Appalachians, how many native West Virginians do we have? Okay, so good. We have a good crowd here. There was a book I ran into a couple years ago by a guy named Colin Woodard, I think, discussing the 11 separate nations within the United States. And West Virginia is part of a collective called Greater Appalachia. One of the hallmarks of Greater Appalachia is a distrust of government. And this is sort of ingrained in us from a cultural standpoint. And as I talk to my undergrad business students, we spend a lot of time discussing rights and duties as citizens, as business participants. And I can talk to them about rights, and they're familiar with our rights. They can recite to you, all the rights that are protected by the Bill of Rights. But when you ask them to apply that in a context, I give them an assignment. There's a great video out there by a guy named James Duane. He's a professor at Regents University School of Law in Virginia. And in this video, Professor Duane discusses why you should never talk to the police. Under any circumstances, never talk to the police. And I show this video to my students, and their minds are blown. And there's a disconnect there. You guys, we talk about our rights. We talk about the rights we have. We talk about the things government can't do to you. And then you're totally confused about the role of law enforcement in our society. Not to say that I have any specific issue with law enforcement. Very nice people in law enforcement. But they have a role, and the role is not necessarily to protect the individual accused. That's where the attorneys need to step in and advocate for those criminals. That's our role in this system. So I think coming at it from that perspective, helping our students understand that rights mean something. And unless you are willing to stand up for your rights, and there's someone there willing to stand up for your rights in court in an adversarial proceeding, what good are those rights?
And just to add to that, with the West Virginia Public Defender Service, I actually served as the Director of Operations and Director of Accounting and Auditing, and I was there for about 14 years. In that time, I was able to meet and work with some various wonderful people, understand that DNA evidence actually first started in Kanawha County by Lonnie Simmons and George Castell in the public defender system, and understanding, looking at these issues and saying, we've got a lot of resources, but we've got to make sure that we effectively use those resources, because the money that we're spending on erroneous stuff, or maybe that's not as effective, we need to actually find the better procedures. And then we actually started trying to move towards a more holistic approach for individuals that are accused of crimes.
Wonderful. So Professor Baker, brought up the rights of citizens. Professor McKinney, could you tell us a little bit about the right to counsel for criminal defendants who are unable to afford an attorney, and what is the source of that right?
Okay. I think it really starts before the United States. You have John Adams, who was the first vice president and the second president of the United States, that actually did counsel some of the British before the country was founded, and I think that led to the Sixth Amendment, the right to counsel. Now, what's interesting about that is in 1911, we actually had public defender offices that were operated from donations in New York and California were the two prominent offices, one on either coast. So you had a lot of people that were doing this work free of charge, that were assisting their community, and were looking at a holistic approach. So, 1911 is quite different than the 1963 Gideon. And I think with that, it really solidified that the fact that there's a triggering event when you're going to remove somebody's rights and potentially face incarceration and remove their right of as an individual to engage in fruitful employment, earn a living, then you have to have some kind of method of due process and afford legal counsel. Now, the problem with that is they never exactly said how much legal counsel that was, how much money is that going to be? And the other issue is what quality of legal counsel. So those are some of the issues that when I was at the Public Defender Office, we wrestled with to understand, there's a limitation with the legislative appropriation. So we were always going back and saying, well, can we get a supplemental appropriation? Well, guys, how much you need? Well, maybe $12 million. That's a lot of road money for some people. And unfortunately, a lot of people that are incarcerated don't vote for our politicians. So who has, who's able to advocate on their behalf? And that's partly why I'm really interested in making the system much more robust, and potentially looking at how we can do this through home rule and how that can be incorporated.
Speaking of home rule, Professor Baker, how does the state's compliance with the right to counsel under Gideon involve multiple levels of government?
Well, it all comes back to money. What's your funding source? Right now in West Virginia, it's public. It's state money. The state controls the purse strings. But those actual spending decisions are very frequently made at the local level. When you talk about the actual billings that attorneys are doing and submitting for approval, a lot of that used to occur through, and Ralph has some firsthand experience in some of these issues that pop up, but the judge has to sign off on those, which creates a court order. So now you possibly have conflicts between legislative and judicial branches. The legislature authorizes the spending, but now the court's ordering the spending. You also have, you throw in an extra element in West Virginia where you have these private corporations that are actually quasi-governmental entities, the public defender corporations. And it's kind of tricky coordinating those with the IRS as 501c3 organizations, even though their bylaws are established by state statute. So you've got federal, state, local elements all involved in this. Ultimately, though, it's going to come back to the money. What's the funding source? If you have, as Ralph mentioned, in the early 1900s, the private funding, If you had more private funding of these sources, obviously you can eliminate some of that concern. But again, the responsibility is on the state to fund these sources and assure the rights of our individual citizens to a fair trial, to due process. And that's what it comes back to. That's the charge of all of our government officials, is preserve due process.
I'll ask both of you this. If the responsibility is on the state, then in your opinion, is the representation of indigent criminal defendants a local matter? And if so, what effect does home rule have on the system?
Yes, I think it is a local matter because when you think of a public defender corporation or appointed counsel, those are county decisions. Those are local decisions. Charleston is different than Morgantown, is different than Martinsburg. And so the economies are different. The rules and regulations are different. The support services outside of just the legal counsel, such as public assistance, SNAP programs, may be different. Services for medical care, for substance abuse are different in different areas. And I think those decisions really have to focus locally because those are the individuals that can identify the resources and look at this from a holistic approach. The way the system is currently, we do have some social workers in the program that allow and do reviews. Sometimes we do psych evaluations, but there's not a real central office that looks at a person and says, okay, you need indigent representation, but we also have to maybe cure some of the issues with food insecurity, with medical care, access with people with disabilities, because those are also individuals that may need legal representation. So yes, I do believe it's a very much a local matter.
Professor Baker, what about you?
And I'd echo that. You know, I think think globally, act locally is well, a phrase that we talk about in our business programs. You know, everything has a local component to it, and that's really the tension that we see in the system as it is you have these local problems, local prosecutors, local courts, local defense attorneys that are hamstrung by the state funding apparatus. If you could democratize that, get it down more to the local level, you may be able to see more custom designed programs, again, more holistic approach at the local level as opposed to the one, you know, the cookie cutter model that's going to come from those higher levels of government.
Before we turn to the specifics of the system here in West Virginia, Professor Baker, are there guiding principles for systems that are designed to provide legal representation for indigent criminal defendants?
Oh, sure. In 2002, I think it was, the American Bar Association came out with a set of 10 guiding principles. And you could probably really consolidate those into about 2 or 3, maybe 4 guiding principles if you really wanted to. And it's not much different than any representation circumstance. You want competency. You want access, equal access to counsel. You want a sense of fairness in the process itself. You want expertise. You know, certain criminal cases are more complex than other criminal cases, just like certain civil cases are more complex than other civil cases. You need to develop some method within this system that you can assure that those complex cases are treated not on the mass production model of running however many cases we need to through a court in a single day. You look at some of these dockets and there's 300-400 cases set for a single day. You know, if we've got an indigent defense or an indigent defendant who's facing a murder charge, we probably need to spend a little bit more time and energy on that than one of the various minor misdemeanor drug possession type cases. So developing a system where you have attorneys who have the requisite amount of expertise, requisite amount of time, of resources available to them to provide an effective defense is really at the core of those guiding principles.
With those principles in mind, let's turn to West Virginia now. Professor McKinney, what does the indigent defense system look like in West Virginia?
It's actually a mixed system. So you have, in some cases, you've got these judicial circuits, and as Casey mentioned, that in each judicial circuit there is a public defender corporation. Now, the term activate is important because currently there are 18 corporations that have been activated that cover 19 judicial circuits. And in some of those counties, there is not a public defender corporation, but there's appointed counsel, and those are private panel attorneys that are basically contractors. So the decision to open a public defender office is a financial decision. It is a local decision because it requires the county commission, the county bar to come together. Appointments are made to a board of directors. The articles of incorporation are by statute, and that's part of the process. And even if you have a public defender corporation, you still have private panel attorneys, the appointed counsel, to actually also assist with the work. Because the issue is when you arrest a group of people, you've got 5 people. The public defender office should only represent one of those individuals because you've got conflict of interest. Or you may have a public defender office that may not have the specific expertise associated with the case, and it needs a complement from a private panel attorney. So that's kind of the way the system works. There's a centralized organization, West Virginia Public Defender Services, that oversees and grants organizations funding for the public defender offices, but they also act as a payment agency, a payment conduit for the appointed counsel. There is an Indigent Defense Commission associated with that advises the public defender services. So there's questions that we could always ask: how can we make it more effective? How can we use our local governments to actually create a better working relationship with the state agency to where we can actually tackle the issues locally, like the opioid epidemic, other type of economic issues, and holistic approaches like food insecurity. That maybe sometimes people commit crimes because that's their choice, or they're only, when they look at it, that may be their only option.
Professor Baker, could you talk a little bit more about how the system is funded?
It is largely, there's a state appropriations. You've got, there's a line item in the budget that is passed to PDS, and then PDS oversees the billings, the funding mechanism of the separate panel attorneys and the public defender corporations, right?
Yes.
And then the distinction between those two organizations.
Okay. Basically, yes, there is an appropriation from the legislature, Public Defender Services. Each public defender corporation submits an annual application for funding. Public Defender Services reviews that applications, make the determination, and justifies those budgetary or grants, and then they issue grants to those offices. Those are actually, the legislature at one point in time had those in one single line item, so both the appointed counsel and public defender service were operating out of the same budget. And then there were some issues associated. Well, public defender corporations are getting better treatment. You're always shorting us money because the money would run out and you'd have to request a supplemental appropriation. And during that 6 months that I'm waiting for payment, or a year, I can't operate. So they actually split those two out. The legislature was smart enough to do that. And so you have a separate line for public defender offices and a separate line for appointed counsel. And at the end of the year, you can transfer money from the public defender corporations to the appointed counsel to reduce the supplemental appropriation that's requested. Part of the strategy that the West Virginia Budget Office had, because it's always, why does West Virginia Public Defender Services actually always ask for a supplemental appropriation? That's actually a political thing from the state. That's a political agenda from the state, because the idea is if we gave them all this money, they're just going to spend it on legal representation. So we're going to make sure that we allow this much, and at the end of the year, we're going to find the agencies that maybe underspent and did this. And transfer the money. I remember there was a lot of legislative changes in 2010 where they changed the billing practices from 4 years after the last date of service to 90 days. And we estimated that we needed about $20 million to take care of the backlog. $20 million is a large amount of money. So it was Cart Goodwin and the governor was Joe Manchin, and Jack Rogers sat down and they had a discussion. And they said, well, there's an easy fix. We're just ask for the money. And it's like, how are you going to ask for $20.5 million? And they said, well, simple. They put it and attached the bill to a teacher pay raise bill and said, okay, teachers, okay, have a union. They said, okay, so if you vote against the teacher pay raise, you vote against the appropriation, and it read something like, there's going to be a $1,500 authorization from the state of West Virginia for teachers, provided that the county funded. Well, the county didn't have to fund it, so there's no funding strings associated with that. But it was a political move to transfer the money from the West Virginia Lottery Commission to the Public Defender Services. So when you're talking about funding issues, that's at the state level, and I think that sometimes the local level can help influence that and really understand the needs. Because at the state level, it was, let's make a guess, and that's part of the problem.
And just kind of, you talk about, okay, alternative funding models. Ralph was telling me something he found in the way they fund indigent defense in Germany. You want to talk a little bit about that? This is interesting.
Now, in Germany, everybody's entitled to indigent representation. So if I'm over in Germany and I get arrested, I can get that free of charge. There's no problem. Now, how do we fund this? Insurance premiums. So in Germany, everybody that's a homeowner has insurance. Everybody that's a renter has homeowner, and it's part of the policy and coverage for the insurance. So there's a portion that's taxed that goes into a central fund to fund those individuals that don't have the insurance. But if I'm a homeowner and have insurance, I just put a claim against my insurance and they pay for it. That's an interesting approach.
That is different than the system we have here. And so before we're talking about the German system, you talked about local needs. So do we see specific local needs here, county by county, for the public defender corporations? Or what local needs would counties be responding to that the state funding decisions might not?
I think in some cases, if you're looking at the opioid crisis, those may impact more so. If there's an economic slump in one area, that could be, it's basically the same issues. The person is accused of a crime. And I think the solutions, when you're looking at a holistic approach, may be different county by county. For example, Weirton had a lot of steel industries. Those steel industries are not there. So what are the jobs? What are the jobs available to an ex-offender? And I think that's where you could have the support that's necessary from the local counties to show, I want to say empowerment zones, but where can these people find sustainable jobs that they can be members of society after the fact? Or is there going to be a stereotype of having potentially a criminal conviction or an investigation that stops me from getting work?
And just to kind of maybe take that a little bit different, and I don't know that I want to use the term NIMBYism, but a lot of these local issues, opioids, job loss, you can say what comes first, the chicken or the egg? Does crime result in these issues, or do these issues create crime? But the fact of the matter is, it's a much easier political sell to say we're going to get tough on crime than it is to say we're going to take a holistic approach and try to solve these other problems, and then maybe that will resolve the crime problems that we're facing in our local communities. I do think that mindset is changing a little bit, and the opioid crisis, I think, has prompted a lot of that. Just the widespread nature of that issue, especially here in West Virginia, but I don't think we're there yet. I don't think we're there yet to the point where we look at this and say, this is politically a popular option. I've got a client I was just talking to the other day. It was a recovery center, and they were getting some grief from one of the local communities about homelessness. And the recovery center is being blamed for the local homeless problem. And it's, no, we're there to treat the homeless problem. We're not dumping these folks on the street. We have our doors open. These people are homeless, not because of us. They're homeless because of the substance use issues. And we're trying to give them shelter so that way they can get into recovery. So you have that. You do still have that element out there that, again, like Ralph said, you take a holistic approach and you see that this criminal representation is just one part of a larger social problem that we've got to change our mindset on in addressing these problems.
Both of you have used the term holistic defense. What is holistic defense? What does the model look like in West Virginia? Is there one model, or do we see different models for the different public defender corporations?
Again, and I think it's back to that point of crime is one part of a social issue, or of a bigger social problem, which is lack of opportunities for folks. Idle hands do the devil's work, right? That's the old saying. Lack of opportunities, jobs, economic, entrepreneurship. You combine that with reliance on public assistance. Indigent defense shouldn't be any different than any other form of public assistance. We have an entire medical industry that's based on a model of reimbursement from public funds. Why is our legal industry not also thought of in the same light? Why is it that public defenders make less than anybody else in the legal industry? Why have we shifted that incentive system such that attorneys are economically discouraged from engaging in indigent defense? So I think when we say holistic approach, it's re-envisioning criminal defense as just one aspect of this social safety net.
And to add on to that, currently with the public defender systems, they may have a social worker in office, but those individuals are looking at the cases and the legal aspects associated with abuse and neglect. They're not there for counseling. They're not there to help with the housing problems or the other issues. We have Legal Aid of West Virginia, which does assist with some of those issues. If there was an opportunity to create a shared office, you would actually be able to use the same accounting systems, maybe some of the same receptionists and staff, but you're treating the individual as an individual and saying, what we're going to do is look at your food insecurity. We have, again, with the healthcare system, we have economic service workers or people from the Bureau of Children and Families that take applications for public assistance stationed at hospitals so that we can get the appropriate Medicaid payer information. Why can't we have those individuals also at some of the public defender offices or at a municipal office if there's no public defender, maybe at the courthouse to take some of the applications to where it would be accessible. And that may actually help with some of the individuals. We're not there yet. So.
Now, Professor Baker, you mentioned the salary of public defenders, and I thought one of the most interesting parts of your article talks about public defenders and whether they're more cost-effective than appointed counsel. Mm-hmm. So let's talk more about the mixed system, how that works on a funding level and salary level, and if you do think that public defenders are more cost-effective than the appointed counsel system.
So I guess what is cost-effectiveness in this context? I think that's number one, a question. What's your mission? What's your goal with any kind of indigent defense system, be it an appointed counsel system or a public defender corporation? But set that issue to the side. I think generally what you see is your public defender corporation attorneys are salaried. So they are getting a flat salary regardless of the volume of cases that they handle, which means they're usually handling a large volume of cases. These are typically the folks in your municipal courts running through the 200-300 cases in a day. So now you have to worry about workload. You have to worry about competency. Are these attorneys getting sufficient time with their clients to provide them an adequate representation? The flip side of that are your appointed counsel systems, where until just recently we were making what, $45 an hour for out of court and 60 for in court. You would be hard pressed to find a private attorney who will take $60 an hour for any work.
Now it's 60 and 80,
Now
which
it's
is
60 and 80,
yeah, which
a little
is,
bit better.
Yeah.
But still, find an attorney who will do a will for somebody for $80. Standard, simple will. I've tried that model. $80 don't cut it, I promise you. So again, I think it gets into managing resources in light of the goals of whatever that particular criminal docket, that particular criminal case situation may entail.
Yeah. And to add on to that, if you look at what's the metric, are we going to go by cases closed? Well, then why not plea everything? That's a case closed. Are we going to look at taking everything to court? Are we going to look at the number of charges that are filed and then dismissed as a metric? So there's a number of ways that we can look at this, but until we actually fully understand and create a mission, other than the mission is to defend the indigent, that's kind of a broad spectrum. How are we going to accomplish that? What are our objectives? What are our minimum standards? And again, with the appointed counsel system, you know, the salary for 45 and 65 was a 1990 case, and basically until recently, for over 25 years, it's the same rates, you know, with no inflation. With the public defender offices, those individuals get a salary periodically every week or every 2 weeks, and with the appointed counsel, I have to wait till the case is closed, and I can't bill periodically, so I'm going to have to front some of the money. So some of the, I may not get an expert, and if I do, I have to go through a voucher system to do a third-party payer, essentially, to do that. So that's going to be another issue when you're looking at quality as well. So sometimes there's some tension between a public defender corporation and an appointed counsel because of the benefit issue, because of the compensation issue, because the way they're a competing environment. So they're good to work together, but I think with the payment for appointed counsel, that needs to be a little faster.
So to follow up on that great discussion of how you measure cost effectiveness when it comes to delivering legal representation, what was the metric that you were looking at, and what was your finding for comparison?
I like the breakdown that we had. It was a purchase price parity. Help me out here. What was the?
It was a purchasing price of parity.
Yes,
and
on a GDP per capita basis, right?
So the idea is this: bread in Morgantown is going to be this different price than bread in California than the bread in South Africa. And from those concepts, if we look at the gross domestic product or the state, then we consider that sort of like the consumer price index, and we kind of match that to figure out where we are in indigent representation. What are we spending as a state as allocated resources versus other states? And
not just other states, but other countries. You can use this metric across cultures worldwide.
Yeah, because it eliminates the need for exchanging monetary issues or currency calculations or anything like that. And what's interesting is Venezuela, South Africa, actually spend more than in their indigent representation than El Paso, Texas. So that's kind of a, wow, where are the resources? Because if you're going to be successful in any job, in any management, in any type of business, you have to have resources. And limiting those resources or not funding or giving support from a political standpoint, from a policy standpoint, will make you fail every time.
And so where does West Virginia fall on that spectrum? Actually, not too bad. near the top of the list in the United States is, on that metric, which shows you just how bad this problem may be nationwide when you're talking $60 per hour ranks well within the United States. That's a scary thought, especially when you've got this, you talk about mission. As a nation, our mission is right there in the preamble, right? We the people of the United States, in order to form a more perfect union. Establish justice. It's the first thing we talk about.
You mentioned how West Virginia is funded compared to other systems throughout the country. Yes, throughout the country and the world, and how it measures up. So let's talk about how the mixed system in West Virginia compares to other state systems and the federal system. Professor Baker, do you want to talk about that, or Professor McKinney?
Okay, yeah.
You're the economist.
I'm the economist. Okay. So West Virginia, when we looked at it, was about the second one. The United Kingdom spent a little more in funding than West Virginia. But considering that we're on that, that's pretty awesome. Now, what's kind of interesting is the public defender system in West Virginia has actually been studied by Spanchenberg, by several other individuals, and some of the UK systems that they do for indigent defense was modeled after the state of West Virginia, which is kind of, wow, that's kind of interesting. So I did have a chance to go to the Birmingham office in England for the and they call it Public Defender Services, and they ran it very similar to what we do here. And what was interesting is Leon, the individual that was running the Public Defender Services, was a graduate of Ohio School of Law. So, you know, again, somewhere local. Japan models their system from the United States. And so it's kind of amazing to see that West Virginia is actually one of the front runners for these type of programs. But are we doing enough? Maybe not. Maybe it's time to reinvent and reinvigorate and make the system a little more robust, because we can't be satisfied with just being, you know, we're at this level. Let's take it up another notch.
Before we turn to reforms and recommendations that you would make based on this system that sounds like a model for the country and the world, what issues do you find with the current West Virginia system? Have there been any problems that you've identified ethically or otherwise with the current system?
And again, Ralph ran effectively the operations of Public Defender Services, and he's got some great war stories in this model that they had to sort through in the payment reimbursement. He's telling me these things, and I'm like, that's an ethical violation. That's an ethical violation. That's an ethical violation. What?
My favorite question. My favorite question. How many hours are in a day? Just asking. So we had one individual that billed 56 hours in a day while they were on a Caribbean cruise. Yeah. There was one individual that over a 2-year period, 176 days in excess of 36 hours. They were working really hard. Okay, so yeah, these are ethical issues.
And the issue is, okay, so I've got 10 cases on the docket that day. I spent an hour in court total, but I'm going to bill each case 1 hour. No, you don't. The one you got on, we had the judge sign the order, so we had to pay it, but then we were able to get them on federal wire fraud.
So the first issue is this. Okay, we're sitting around having a discussion in the office, and this is at the time I was at the PDS office with Jack Rogers and Russ Cook, who was the acting director after Jack left. How do we do this? We've got state judges signing these court orders, and one of the ethical issues is, well, I can see that there's a mistake here, so what the office would do is they would just strike it through and say, just reduce it. Well, didn't you modify a court order? Don't you need a judge's signature on that to modify that court order for payment? So there's some of the stuff on the Public Defender Services that was being done just because it was easier to identify those. The one issue was, hey, so going back to what we were looking at, how do we, call judges out that are state judges? Well, and a couple of us sat around and thought about it, and I said, well, they mailed these, didn't they? Well, what's that got to do with anything, McKinney? it's mail. Don't they get in trouble for mail? And they're like, yeah, it's only about wait a minute. So the first thing that was done is the filing. So the individual was from Martinsburg, and they were charged with 99 counts of mail fraud, 12 counts of wire fraud, and 1 count of conspiracy. And they decided that they didn't need to show up for court, so they're in prison. So that's
federal,
kind of scary.
And there's a reimbursement order part of that, and doesn't
Yes.
you tell me that the federal prison docks their pay and sends a check to PDS?
Well, the
cents a
restitution,
month or
yeah,
something?
there was a restitution order, and so suddenly I got this check in the mail from the Bureau of Public Debt, and I'm like, why are we getting a check from the Bureau of Public Debt? $7,500. So I call, and they laugh, and they said, we'll get back with you. I'm like, why are you laughing? I'm just trying to call about a check. Well, apparently they entered an order for her prison wages and garnished them at 20%. So you get a quarter an hour at the time. And they had this clause that they said excessive rate retainage that said anything over $15 in the client's trust account that the IRS would sweep. So the IRS was actually collecting the money and submitting it to us, which was kind of crazy. So her husband would send her a check, $100, and since it was over $15, all that money was considered excess retainage and take it. So she really upset the federal judge.
And then I think my favorite story you were telling me dealt with conflicts of interest. Attorneys as witnesses to crimes.
Oh.
Yeah.
Okay, I got to tell that story. We held a public defender conference in Charleston at Embassy Suites. So Jack Rogers was driving a car. This guy rolls across the hood of his car. He was late, so he was, kind of slow trying to park. And he starts to yell at him, but he noticed he had a gun. So he apparently just robbed the United Bank building in Charleston. He goes through the Embassy Suites kitchen, so there's money flying everywhere because he's running through there. And he passes Menace Ketchum and Judge Spalding at the public defender conference. So they tackle him at there, and we have to delay the conference for about 15 to 20 minutes. Now, the first thing that people started laughing is, wait a minute, who's going to represent him? Because guess what? Everybody's here. All the public defender's office, the appointed counsel, the judges. I mean, at that point in time, what do you do? Because the cops are like, we're going to need all your names.
So do you kick it up to federal court because it's a bank robbery? Well, the folks in the same system are doing the work in both state and federal court. So that was, yeah.
So, I mean, what do you do at that point in time? So it's little things like that that are kind of interesting, but that sometimes we don't account for. And, that's part of the difficulty sometimes.
Beyond reimbursement issues and conflict of interest issues, do you see any other structural issues or other problems that you've identified in the system that you'd like to highlight?
Again, I think competency and expertise. We've got those ethical obligations that we are not supposed to take on cases that we are not qualified to take on. West Virginia is better about this. Once upon a time, all attorneys in West Virginia could be randomly appointed to represent indigent defendants, whether or not you knew the first thing about criminal law. A guy I used to work with told me a story. He was fresh into the bar, and he does real estate law. Fresh into the bar, hadn't even received his certificate yet, and he gets appointed counsel for this guy. So he drives up to meet the guy, and the guy won't talk to him. He wants proof. Again, this is the suspicion of government that's kind of ingrained in all of us. He wants proof that this guy is an attorney before he'll talk to him. So the guy I worked with he just happened to take his buddy with him, who literally had his law diploma framed just then, that they'd stopped on the way at the framing shop to pick up, had it with him in the car, and the indigent defendant said, okay, he's got his law diploma, that's good enough for me. He's my lawyer, not you. We're not there anymore, which is good. We do still have, it's a voluntary system. You don't have to be appointed attorneys, but I do think those competency and expertise issues are still there to an extent. And again, it's just a matter of the market. Your best attorneys aren't going to be doing the work for $80 an hour.
I think the payment issue is one issue. I also look at when you're talking about the structural changes. The Indigent Defense Commission, the chair of that is the Executive Director of Public Defender Services. Potentially reworking the Indigent Defense Commission to have its own chair to take more of an active role, to potentially expand the membership on that commission. The reason that the public defender corporations were put into place was a requirement from the local support system from the county bars, the county commissioners to get involved. And I think that there's a possibility through home rule that we can actually create robust offices that are holistic offices within Morgantown or Charleston that look more beyond the need for criminal representation, that looks at the other ailments and society issues that may be impacting the person's quality of life, or that could be barriers. Because sometimes if you've got employment barriers, you get desperate. Okay, sometimes when your kids are hungry, you get desperate, and sometimes we have to think like a client, so to speak, and put ourselves and say, well, I'll never do that. Well, never say never.
Right.
It's possible.
And even if you don't do it, doesn't mean you can't be accused of doing it.
Yes. Yes. In Florida, the public defenders are actually elected. They're not salaried, where they're salaried, but they're elected offices, just like the prosecutor. So, and in discussing with those individuals, how did you get elected? And they said, well, we can't say that we represent criminals. What we have to say is, if your constitutional rights are violated, we have a minimum standard that is protection of constitutional rights for everybody, and you would want representation if you're accused. So that's kind of an interesting stance of, hey, I'm a public defender and I'm elected.
You spoke about modifying the commission and then what they do in other states, but are there any improvements that you two would recommend to respond to the ethical violations that you discussed, or any of those other structural issues?
With some of the billing schemes, that's been corrected through the 2010 legislation that has 90 days from the date of service. The online voucher system, so you have an electronic system now that people are putting in their funding and their billable hours, so that also triggers an expectation, so we can actually reasonably estimate what the amount is for the need for an appropriation request is. What would be very helpful, again, if we're using this online voucher system, I'm looking at apps like Uber, and what happens when you get an Uber? You're charged. What happens if you do Grubhub or some of the other apps? You're charged. How come as an attorney, I'm not an attorney, but as an attorney of an appointed counsel system, how come they can't get payment periodically? And that, I think, would alleviate some of the issues. The other issue that we have is some cases, most often these people were inflating the numbers by about 30%, because they were factoring their claims and assigning them to other places to get the money now, because that's how they had to operate. You've got salaries that you've got to pay, and waiting for a check from the government. When are you going to get that?
And I think too, just from a little bit broader perspective, it's again, shifting the mindset on this from we're representing criminals to we're guaranteeing everybody's basic fundamental constitutional rights. That is a more popular political sell. Who here doesn't like their constitutional rights? Right? Who here loves their constitutional rights? Yes. No we know that because we're in the legal industry. And you go out in the street, but again, I talked about this with undergrad business students. Everybody loves their constitutional rights. I think if you can shift that focus, not only do you get more, I think, voters into that, I think you would get more lawyers interested in doing criminal indigent defense. It's not about defending the accused, it's about guaranteeing rights. And again, that raises that issues of competency, because people get passionate about these things. And identifying those people who are really, truly passionate about liberty and rights and constitutional guarantees goes a long way in assuring that minimum. We ought to assure more than the minimum. We ought to assure quality representation, no matter what the setting is. And that's true for indigent criminal defense as well as it is for Fortune 500 companies.
So that's all about modifications and changes you would recommend to the current system, but how would you structure and fund the ideal public defender system? Would it be the West Virginia system? Would it be a state system entirely, or involve an element of local control?
I hate thinking about ideals for two reasons. Number one, it's a whole lot easier to identify what's wrong with the way things operate than it is to identify what's right with the way things operate. Sorry. So that's a practical issue. The other thing is we also don't want the perfect to be the enemy of the good. So can we make steps towards progress rather than the ideal? So what are some good ideas that might help us get better as opposed to what's perfect? I really think the Florida elected public defender system is a real interesting thought. We elect county prosecutors. Why don't we elect the defense attorneys too? And then again, some of the funding models. You go back to we talked about Germany, which is and Ralph was on this, and I'm going through my mind like, okay, so what are the economic incentives here that folks are gonna just raise Cain about if their insurance premiums go up, and how much money are people willing to pay for, a guarantee of their basic fundamental rights? And I would hope that people are willing to pay for that. It's a shared responsibility, I think. We are looking for a more perfect union. So again, those are some ideas. I don't know that I know what the ideal is, though.
Well, let me expand that a little further. I like the way the West Virginia Public Defender System is set up because it does have a presence at the Capitol complex and could advocate. So from a state broad policy perspective, I think that they should be able to establish minimum requirements. And where the home rule would be beneficial is the local municipality or the local government could actually create and structure some of these organizations or activate them and run them as holistic offices and bundle the perhaps legal aid processes, maybe some civil rights attorneys, because sometimes a person that may be accused, there may be multiple issues with that case. So it could be civil rights violations. It could be other issues that are not being solved. And I think if we bundle those, then we could actually have an economy of scale. Looking at Workforce West Virginia, some of the grants for education and training could provide individuals with skill sets so that they can become employable. So maybe as they're being accused of the crime and they're going through the process, they're also receiving maybe public assistance, maybe they're getting some skill set training so that they can advance in their career, or if they don't have a career, that they can become gainfully employed. As I'm going to pick on Jack Rogers, and he said this best. He said, if I can eliminate poverty, child abuse, alcoholism, and substance abuse, we may not be talking about some of these issues.
Before I open up for questions, would either of you like to share anything else with our audience?
What do you got? You got
Covered
anything?
it all?
I think we covered everything,
Okay.
yeah.
Are there any questions?
Coming from a municipal attorney's perspective, who has limited finances for our office, funded through our local governments, versus the state funding that public defenders have, and the time that we spend, when you talk about the cases, there's usually one municipal attorney on the prosecution side with a myriad of other representation within the room, including several people from the public defender's office. I just wonder how, when you talk about the holistic and municipal governments taking on some type of an extra burden for social services, which are usually filled within, say, a community development department, et cetera. How do you justify that? Because the public funds in the municipality are solely relied upon to pay municipal attorneys to prosecute on behalf of the local government and the police departments. And when you talk about $60 and $80, that sounds pretty good to a full-time municipal attorney, because that's not on our paychecks.
Right, and I understand that. And when you're looking at the $60 and $80 rate, that actually is including overhead, insurance, pension, and all the other benefits that are tied into that. So the people that are appointed counsel, they don't get any benefits. So those rates are what it should cost their law operations to function. So that's where those rates come into place. So when you're looking at the shared governance, there are local support and sometimes nonprofits, churches help sometimes with the food. So maybe having each municipality can choose how involved they get, and I think that becomes a community issue. In some cases, you could potentially apply for block grants for opioid epidemics and treatment. You could talk to churches about providing counseling. So I think the municipality would be the one to foster items under an umbrella that they would have a lot of bridges built so that they can reach out across those bridges for the holistic services. So I don't think necessarily it would be a super burden on the municipalities. Yes, there's going to be some extra work involved, because with any type of relationships, we have to cultivate it, we have to build trust. But I think it would be more of a stable environment, because in some cases when you have a public defender office within the county, people know that that's there. And even if they have a legal question or have some issues, they sometimes stop in and have a conversation. And I think that's what you want. You want to be able to have a presence within the community to have the conversation to make sure that people are doing the right things.
And just add a different thought. The Ohio model, because I'm practicing Ohio as well. There's a statutory mandate in Ohio that if you have a public defender office in a county, it has to be funded at the exact, well, not an exact same, at a comparable level to the county prosecutor. If you have one. If you have one. There's no mandate to have one. So what you have are a lot of counties that just don't have a public defender office because they don't want to fund that public defender office at the same level as the prosecutor.
Great question, focusing on the municipality. Is there another question?
There we go. Hi, thank you for coming. So kind of on that same line of reasoning of like comparing how much money the prosecutor spends or how much law enforcement spends versus the amount of money that is allocated for public defending, and also in sort of that decriminalizing certain drug offenses. You know, it's like if we're criminalizing things that maybe shouldn't be criminalized, you're going to put public defenders in a difficult situation, because if you're spending $100 million on law enforcement and prosecution, and you're only spending $50 million on public defending, well then you're you're in a difficult spot, and so maybe, I'm wondering if you've done any research on the relationship between the amount of money spent on law enforcement and prosecution versus the amount of money spent on public defending, and sort of the second part of that question is like, are we actually reducing crime rate or making people safer by criminalizing some drug offenses or minor crimes? And maybe the solution isn't necessarily to spend more money on public defending, but just reduce the overall money that we're spending on law enforcement when it's really not bringing us any kind of positive outcomes. And I think that goes to your point about tough on crime, this sort of political talking point that people get caught up in, but it's really not making our community safer or better. So I just wanted to get your thoughts on that.
I think that, I have done research looking at the prosecutors as well as the public defenders. The prosecutors are more well-funded than the public defenders' offices as well as services. But they also have to do a lot of the investigation and other things than the public defenders. So I can see where that may be needed. The question with the criminal activity, and are we basically attaching jail time for things that we shouldn't? Yes, I think that there's some issues that maybe if we look at our criminal statutes, we need to reduce, or maybe we need to focus on community services, because once a person is incarcerated, that changes their social groups that they identify with. And in some cases, if you look at organizational behavior and social identity and organizational identity, on all those concepts, when we're around people, we start to pick up the traits, we start to understand the jargon, the lingo, and I think sometimes that putting people for those minor infractions into a prison system actually creates a better opportunity for them to be successful and upgrade their skill sets. So maybe it's the community service that's needed, or maybe some of these issues that we've got attached to criminal penalties may not necessarily be needed. So does that answer your question?
And I think, again, that goes back to the local nature of some of these problems, and maybe the answer needs to be local, not state-driven. And I think a great example of that are drug courts. Our drug courts have been hugely successful in removing folks from the criminal system, getting them back on a path towards being a productive member of society. I think that's a model we really need to spend some time looking at and seeing, can we extend these concepts to other areas, other social ills that are feeding into this criminal cycle.
And to add on to that, when you're looking at a drug court, you have representation from the prosecutors, from the public defenders, and they're all working in conjunction. Yes. And when the first drug courts came out, one of the biggest arguments that public defender services had was the fact that, wait a minute, we've got public defenders that potentially may be asking for jail time for their client. That's a conflict of interest. So how do we mitigate that? How do we get involved in that? Do we show up? Do we not show up? And I think the drug courts were an innovative idea, and they're very successful, as Casey pointed out. And I think that's a new, innovative way of thinking to tackle the problem as a social problem and go beyond that. And most of the drug courts are really local endeavors. Mm-hmm.
Thought-provoking. Thank you. Is there another question? If you'll
Hi.
wait for the microphone.
Yes.
Oh, there we go.
Hi. Mr. Baker, you had mentioned that the state used to have a mandatory appointments list
Yes.
for criminal appointments. Monongalia County tried something similar with a court order that required anyone practicing in the county for its first 2 years to do mandatory misdemeanors. And this has been a part of an ongoing conversation about putting a public defender's office in Monongalia County, and I think the discussion is still happening, but I'd be interested to hear you guys' thoughts on whether an appointment list versus a public defender is a good use of local involvement.
I have 13th Amendment concerns about compulsory representation. I don't want a lawyer who doesn't want to be the lawyer for the client. That's not going to incentivize quality representation. If you're a lawyer, you need to be involved in that case because you want to be involved in that case. I would much rather spend that time and energy in the debate fostering passion for the issue as opposed to compulsory participation in it. If that answers your question. That's my perspective. Not my opinion, my perspective.
Do you have any thoughts on that?
Yeah, I like the idea of if you're going to have a list, it's got to be voluntary.
Yeah.
The other thing that attaches to the list is not just the fact that they're able to practice law, but what areas are their expertise. Because in some cases, you may have somebody that is great at traffic violations, but doesn't know anything about murder charges. And then you have some people that may be able to do capital offense, but not traffic violations. So again, the expertise is going to be important so that we can appropriately match the attorney with the client. And in some cases, you actually have to talk to that client because personalities are slightly different sometimes, and some clients do not want certain people representing. I don't trust you because I've never seen any proof, therefore you're not what I expect. So there's those issues as well. And I think that in some cases with the applications, we have to look at the accessibility of a client. So we sometimes have clients that are deaf or blind or people with disabilities, and understanding that they have special needs, and maybe some people don't acclimate well going to certain buildings, and maybe they have to be visited at home. So having, again, the right fit is important.
We have a question up here at the front.
Yeah. Many cities in West Virginia made the decision to not bring charges in the city courts for misdemeanor offenses, but rather the decision is to put those off to magistrate court. Based upon home rule, do you think that that's an appropriate decision to be made by a city? Or do you think that that's them giving up their responsibility?
I think, and again, it's resources. Why am I going to spend city resources when I can punt this to the magistrate courts and let them spend their time and energy and resources? That's the justification there. But, and again, it's shifting the mindset here from I'm spending resources defending the accused or prosecuting the accused into a mindset of I'm solving I'm working on one part of a larger social problem. Typically, I think municipalities want to solve the problems of the municipality. Understanding that this is part of it requires their involvement, especially as you consider home rule. What do you think?
Well, to address the issue associated with taking a municipal, and I think you're delegating that work to the county, and that's perfectly acceptable. And I think that that's part of the building relationships, because in some cases you have some cities that their city attorney is a volunteer and a real estate attorney, or I can draft a contract. I don't know criminal law, so why do I get involved in that? And I think that's where the partnerships come in, and the city determines what its course of action is. So the municipality does and says, you know, what we're going to do is we're going to delegate everything to the county to prosecute and take care of, because what we like to do is specialize. And when we specialize, we're able to do things that are great and exciting, and our performance increases. And I think that's through specialization, what you have to do is realize that you have weaknesses and you can't tackle everything, and identifying the other people that have strengths, such as maybe the county, because that's what the prosecutor does. And delegating that to the county allows you to focus on maybe some of the economic development incentives, maybe some of the other problems that you have within the community. You know, energy management, things like that become really important. And I think that in some cases may be the best decision that you can make.
if you put that requirement on the cities, would you then say that it would be the state's responsibility to reimburse the cities for that? Because as we know that fines and court costs don't stay in the city level, they go to the state. And so you're imposing a requirement upon a city to prosecute these cases. And of course, as we all know, not every criminal case in West Virginia gets a court-appointed lawyer.
Correct.
And maybe that's a flaw in the system, since everything that's a violation of statute is a misdemeanor in West Virginia, whereas other states like Maryland, District of Columbia have different requirements, have offenses or citations. Also, if you go to the District of Columbia, you're not entitled to a court-appointed attorney unless you're facing up to 90 days in jail. Whereas in West Virginia, if there's any jail time, any possible jail time, you're entitled to a court-appointed counsel. But like I said, if you put the requirement upon the cities, shouldn't we get some of the fees back?
To answer that, I will say this. In Charleston, the Kanawha County, which is the 13th Judicial Circuit Public Defender Corporation, actually assigns a public defender to the county, and so, or to the city of Charleston for municipal court. So that's actually being paid for through the state funds. In the current version of the West Virginia Code 2921, it does allow any organization that is seeking indigent representation or wants to do that to actually file for a grant. So in some cases, your municipality can say, well, we'd like to have a public defender for our municipality, and we will file with the West Virginia Public Defender Services a grant application requesting that the position be funded at this and the rates be funded at so-and-so, and they can actually, you can sketch out a budget and say, this is what we'd like to do. This is our proposal. And that actually has to be entertained and reviewed as part of their function and their mission. So, you know, it's not, so the answer is yes, you could probably seek additional money. I can't guarantee what the administration would do, but that is an avenue to assist with some of those issues.
Thank you. Here at the front.
Can you talk about what, if any, role the Public Defender's Office has in lobbying to help decriminalize some of these jail-related offenses, so that it seems to me that you would have the factual details to be able to talk about what the financial repercussions are of the level that you're having to fend these types of crimes?
So what we did is we always looked at the financial. That was kind of the most important things for the legislature. How much is this going to cost? So the financial information is there. Anytime that there's a bill that has a criminal penalty or modification, there's always a financial note placed within that comes from Public Defender Services. And in some cases, we started expanding those financial notes to include other information that says, you know, this is going to tax for jail time. There are other issues outside of the finances that we have to consider. So there's those points. The annual report is another tool that was made public and put on the website when I was there. One of the items that we wanted to do is create a more transparent office. So by making things available on the web, we were also able to lobby the legislature, and I can tell you that from the executive director, Jack Rogers, when I would not see him for 2 months. So during the legislature, he was having lunch with everybody. Okay, he was doing everything that he could to lobby. What was an interesting story is occasionally I'd have to go with him with the meetings, and the first thing he told me is, he goes, McKinney, don't wear a suit. I said, what? He goes, don't wear a suit. I want you in a golf shirt or something relaxed, and you're not sitting with me when we go to these meetings. You're sitting on the other end of the room, and you're not taking pens or paper or anything like that, because I need you to listen. And when I leave, you're going to leave a half an hour later, because I need you to understand what's going on in the room, what they're talking about, what they're complaining about after I leave, because that's when the discussions occur. And having that was actually a wonderful strategy, because I was able to go back and say, these are the issues that they're talking about. And then the next day, he would go visit those people that are identified, because I had to study who was elected, who's sitting here, and take all that here. He would meet them and say, hey, I'm treating you to lunch. Let's have a discussion about the issue that I heard that you may have raised. And because I was sitting in the corner, nobody looked at me. Because I didn't have a suit, nobody looked at me. The other thing he said is, since we're asking for more money, don't look like we have any money.
Well, and you've got some tangible results out of that too. I mean, your 2009 report was the basis for a lot of the reforms that happened through the legislature, right?
Yes, yes. I did an economic analysis in 2009, which was part of the Indigent Defense Commission report, that actually got the increase for the attorneys. Subsequently, the 4th Judicial Circuit in Parkersburg was formed, and I did all the financial stuff and projections for the offices years in advance, even 5-year plans, 10-year plans. So the reports that they're using still are based on the stuff that we had done. The prosecution for billing schemes was actually started in the office and allowed, transferred to basically the U.S. attorney, and we showed those individuals how to do the analysis. So because it was more of a conflict of interest if we were doing and trying to prosecute people for billing schemes than it would be for the U.S. attorney. So
It's an interesting partnership.
So some of the ethical issues is like we probably shouldn't be doing this and testifying as witnesses since we're also representing the other people. So.
Is there another question from an audience member?
Hi. I've only seen this done in one county, but I'm trying to think of ways that we can save money for the state or put money back in to the state coffers in order to pay appointed attorneys. But in Marion County, at the end of a criminal matter, the 2 circuit judges, they require that all defendants that have appointed counsel pay their attorney's fees, and it's included in their court costs and fines. And I mean, it doesn't affect the appointed counsel's pay; they get paid, but then that client, it's a part of their court costs that they have to pay back all attorney's fees. So that's the only county I know that does that, and I didn't know if any other counties do that, and if that actually helps, if those people if they do even pay that.
To answer that, I think Marion County is the only one that may do that. I have some concerns for that. For example, if you're indigent and you can't afford to pay anyway, there were some bills that were talking about paying a co-payment for court counsel. So if you're indigent, what we need you to do is pay $20 or $25. Well, I don't have that. Well, you don't get a lawyer. So I think that up front was defeated on that purpose for the right to counsel. The restitution and the payment would probably most likely go to the county, which may be transferred to either the county coffers or to some other issue, okay? And so my concern is, are we doing that and damaging the client economically, or is there another alternative? Instead of maybe assessing money, we can make the community service more of an option. We can have them discuss some of their issues. We can have them do certain work. What was interesting is Raleigh County, at one point in time, they would go through and pick people that had specific skills. So if they had a plumber or a craftsman, those are the people that they would actually target for community service because they had crumbling buildings and a way to get some of the stuff done, which is kind of an odd way to do it. But how can the people actually contribute and get experience and become a part of the community? And I think sometimes what we do is if we find people that can't afford it, what we're doing is pushing them outside the community and kind of ostracizing them.
Professor Baker?
I'd really like to see how that policy is structured before commenting on it too much. But yeah, I've got some concerns there. If we're making indigent defendants pay for the cost of their defense on the back end, that will give you the defense, but then you've got to pay for it even though you didn't have money to pay for the defense. That I'd like to look at that before, because that raises some concern. Like there was actually an application fee at one point in time, right before,
They tried, but it
was defeated. So
it was defeated.
is this just a way of masking an application fee? But we're just not going to charge you the fee until the case is over. I don't know. I'd be curious to look at that.
Any other questions? Yes.
Sorry. I just want to bring this up so I can tell my dad later. He's been practicing as a criminal defense attorney for as long as I've been alive. And he complains about there being no investigation into a client's actual financial background, that when they fill out the financial affidavit, you look through and it's just zeros on everything, and they sign off and the magistrate signs off, and and we get clients appointed to us that have jobs and have money, but they just fill zeros out on the financial affidavit. And he thought that if there was some investigation done, maybe we would require those people to actually pay for their counsel because they do have a job and make money, and that would save the state some money in the long run. But I just was wondering maybe what your thoughts were on investigating the actual financial background and investigating the affidavits and make sure they're telling the truth on those affidavits.
Well, the application was recently revised, and it does have check marks for income, food stamps, and other related. How are you meeting everything? Because if you have zero income, how are you meeting your incidental needs? And I think that I proposed this several times, was if you're looking at an indigent, to determine indigency, there's some of the easier tests. If they're eligible for food stamps or Medicaid, it's pretty much the same guidelines or similar guidelines. So you should be able to give them a waiver for that. If they are working and there's a job and they didn't disclose, then maybe there's on the new application, it does say this can be charged. You can be charged for criminal activity for that. So could you get restitution from that? Yes, I think you're absolutely right. If they don't meet the qualifying guidelines, then you can ask for restitution. Are there investigations into that? Again, the resources aren't there. It's supposed to be, if there is a public defender office or the magistrate office, they should be able to look into those items. If you had a holistic office, then you can actually tie in. If you're making the application, you also have to make an application to the DHHR, which does have the resources, and they can actually use their systems and cross-match with Social Security records and employment records and other things. Is there a central database that perhaps we could create that allows us to do the cross-matching with workforce, with Bureau of Employment Programs, those agencies, to determine if wages are available? So there are areas that we can explore, yes. At present, again, the investigative items, it's really not on the table because they're working on other larger issues, and that's why I think sometimes in the local community it may be better addressed by a local decision to actually focus on it. And maybe that's what Marion County is doing with the restitution. Okay, you've got an attorney, however, what you've done is you've got a job and you didn't disclose, so we're going to make you pay all this money back.
And then maybe this is a good segue into the consumer panel. I got a Fair Credit Reporting Act light bulb went off in my head. If I'm doing a financial investigation into a person and making an adverse decision based on, I'm denying you counsel based on my investigation into your financial standing, does that trigger certain Fair Credit Reporting Act obligations on behalf of the local court? And I don't know. I'd have to look at, anybody know, top of their head, Fair Credit Reporting Act inside and out? It's been a while since I've looked at that one. I don't even know if county governments would be subject to the Fair Credit Reporting Act or the court system. But if so, yeah, to me that's, obviously you want to control for folks who are taking advantage of the system, defrauding the system, but I don't know that you can deny counsel to someone just on the basis of they lied on their form.
With that, is there any last quick question? I think we have time for one more. No? Okay, thank you. Please join me in thanking Professors McKinney and Baker.
Yes, thank you to our panel. I do want to just have a few quick announcements. We're going to have about a 20-minute break. You guys can grab more food and coffee out in the hallway. If you are here for CLE credit, you do need to check in with Lauren at the CLE table. And we're going to keep announcing this throughout the day, but before you leave, you also need to check back in with the CLE table. So we will start the consumer panel in about 20 minutes.